Good evening. Welcome to another interesting program of the International Grapevine. This is your host, Wallingford Lee. Tonight on the Grapevine, we're going to have the opportunity to talk a little bit about the court system and more importantly, about human rights and access to justice. It's a very sensitive matter when we talk about the court system and what have you. And one of the reasons why we're doing a program like this is somewhat educational for you to understand how the court system works, the pros and the cons, and what you can expect. And more importantly, we also have on board a very great attorney who can talk to you about some of the issues then when you go to court. Well, we feel very pleased and honored to have our two guests. I'm talking about the Honorable Karina Alomar, a veteran attorney and a former president of Latino Lawyers Association in Queens, New York, and she's now a judge. She was born in New Jersey by Puerto Rican parents and Ecuadorian parents. Again, it gives us a great deal of satisfaction to have her as our special guest. We also have on our board today the Honorable and a friend of mine, Nestor Diaz, who happens to be an attorney for over 25 years, serving the community of Queens for a long time in many different ways, in immigration matters, in criminal matters. And not only that, he has been a hard worker in the community. If I sit here tonight and tell you the amount of things that this great gentleman have done for the community, will be here for a long time. Nestor comes from Dominican background, his parents, but he was born and raised in New York City, and that make him an honorable guest of mine. Welcome to our show, both of you.
Thank you.
Well, one of the things that we wanted to talk a little bit tonight is about what is a civil case? Let's put that question first to the Honorable Karina Alomar.
So a civil case is a case where you're basically seeking compensation, rather than punishment for an act. It usually can involve such things such as a contract, a personal injury action. It could even be a divorce matter, a family matter, but anything that does not involve a request for punishment, such as jail time or a fine. So you're basically asking to be compensated for a wrong that you believe somebody else did to you.
Let me just say, add to it. And Judge Alomar indicated that non-criminal. Basically, anything that's not criminal is civil. That's one simplistic way of saying it. Because if it's criminal, it's governed by, at least here in New York, the penal code and criminal procedure law. And there it's in criminal law. Anything that's not criminal related could easily be found in the civil court. And the civil court here in New York City is covered by the civil court and the Supreme Court. And just let me give it a minute. Right now, Karina Alomar is a civil court judge, but she's on the ballot for November 3rd to be, God willingly, elected to the Supreme Court. Okay? So
That'll be great.
So she's going from civil to Supreme.
Well, she have an impeccable record, and that's a very good thing. We hope that she make it over there. Well, you know, it's interesting the explanation that you gave, because one of the questions I wanted to ask you personally, Nestor, what's the difference between a criminal case and a civil case? What's the difference?
And do we have, Attorney, you want to say something?
Well, the difference between a criminal case and a civil case is that in a civil case, you're asking for monetary compensation. Whereas in a criminal case, you're asking for somebody to be punished for an act that a wrongful act that they've committed against the penal code. So you're asking for either jail time or some type of probation or a fine. Whereas a civil case, you just want money.
I guess civil case to a certain extent is like mortgages, divorce, money loan out, that you didn't get paid on, and stuff like that, or car accidents and stuff like that?
Correct. So if and sometimes a case could be both have civil and criminal repercussions. I don't know. Let's say a drunk driver hits someone,
Right.
he kills him and injures him, and he's prosecuted in criminal court, but there may be a lawsuit against him in civil court.
Right, there could be either a wrongful death or another type of personal injury action. So for instance, a drunk driver gets arrested because he killed somebody. They could be prosecuted for the criminal act of driving drunk, and they could go to jail for that. But also if the individual has insurance, or the individual has a good estate, they may decide that it's worthwhile to file a civil action for monetary damages that the victim sustained as a result of their injuries. So for instance, if somebody was killed as a result of the drunk driving, the family of the decedent could file a case for wrongful death and get a judgment against the decedent.
That wrongful death, Nestor, can it end up into a criminal court?
Well, like in my example, my hypothetical, like I said, it started criminal court. If if there's evidence that he was driving and
Under
the
influence.
influence of alcohol and injured or killed the person, then he's looking at both courthouses. Go ahead.
For instance, the good example would be the O.J. Simpson case with Nicole Brown. O.J. Simpson was prosecuted for the murder of Nicole Brown. He was acquitted, but then the family of Nicole Brown and the other gentleman sued him for wrongful death, and they
On the civil
judgment. As a result, any money that that O.J. Simpson has earned has to go to those family members until such time that the amount of the judgment is paid off, and that judgment accrues interest. So in the state of New York, that judgment is that interest is 9% annually, and it's compounded. So if you have a judgment, worth, let's say, $20 million today, in 20 years, it's a lot more because it's been accruing 9% interest.
What happened if that person, in a case, they have own Social Security? Can the Social Security be tapped into?
There are usually monies that are exempt from being collected. So usually Social Security is exempt. Certain veterans benefits are exempt from being collected. So there is a long list of income that is not subject to collection for a judgment.
Does that include a pension also?
It depends. Certain amounts in a pension can be obtained and others cannot.
Right. The reason why I asked that, most cases, guys who have worked for a long time has a pension, has a Social Security, and they get themselves into a problem. So I kind of want to know if there is a line where that can be tapped on the civil situation.
So usually the Social Security, the answer is no, but the pension the answer is usually yes. They can collect a certain portion every month from that pension to satisfy the judgment. I believe in New York State, it's 10% of the monthly amount.
See, Mr. Lee, this comes as an issue many times in matrimonial matters, right?
No, because
But by the pension, I mean, in terms of pensions.
Well, the pension it could be different, because if somebody if let's say Mr. Jones gets a judgment against Mr. X for $10,000, Mr. Jones can ask the marshal to garnish the pay of Mr. X up to 10%.
Okay.
And that will be done until the judgment and the interest that it's accrued is paid off. Pensions are a little bit different as far in a matrimonial case, because in a matrimonial case, if there is a judgment as a result of child support or spousal maintenance arrears, the spouse can request a judgment, can request that the marshal execute on their pay, but it's up to 50% of the pay.
I see. But in a divorce case, let's say the guy is retired and his wife is still working, but she doesn't make as much as he used to work. Can she go after his pension if she have children?
Of course. She can still go, that's his income. And let's be clear, I'm not giving legal advice. I'm just,
No, I understand. We're just explaining certain example of the situation.
but the pensions are fair game. In a matrimonial case, the pension is subject to equitable distribution, meaning that if the spouse who does not own the pension can seek a share of that monthly pension, and in addition, the amount that the pension holder continues to receive, that is subject to garnishment in the event of those child support arrears, and it's also considered income. So if a spouse, if a person is getting divorced and you have, let's say, 2 children, the court would look at the entire income, all income from any source, including pensions, veterans benefits, and they would determine what is the appropriate amount of child support.
Now, listen to Judge Elmore says something important. She said, equitable distribution, not equal distribution.
Equity.
They measured on a variety of factors. What's equitable? What's fair?
What is fair under the circumstances? What's fair to you may not be fair for
To
somebody.
the other person.
So it may not be 50-50. It could be 75-25, 65, whatever the situation calls for.
Well, it's ironic that we're talking about this. I didn't plan it. But right away, in these answers that I'm getting, it reminds me of Kramer versus Kramer, that movie. That was a thing that opened up a lot of men's eyes with the court system and what have you. The way his wife went after him in court, she wanted something that was fair-minded, but once they met with the attorney, they wiped him out. So I was just thinking about that when we talk about fairness and going back and forth. I got one question that I'd like to ask Mr. Diaz. Is there fairness in our court system? I ask you that as an attorney because you have had many cases. You don't have to give me a name or what have you. But what is your interpretation? And one of my friends asked me to ask that question to the attorney and then to the judge.
Well, let me say this first of all. Like Judge Alama, who's a candidate for Supreme Court,
Mm-hmm.
and I am blessed to be also on the ballot. I'm a candidate for civil court. So she's leaving, and I'm going in, God willing, if I get elected. And as a result of that, we cannot give opinions. So I'm not even a judge it, but I'm bound by ethical rules. So we have to be very careful. Now, that being said, that we can't give opinions. Is there fairness? We always, that's one of our goals, to seek fairness, equality in the courtroom, to aspire to the cases that come before us, to make decisions in a fair and equal way. When we say fairness, and I think Judge Allen could add more to this, fair and equal way, not impacted by bias, prejudice, things like that, racism, all sorts of things. Judge a case by the evidence presented. Judge Elmore?
Earlier this year, I had the opportunity and the honor of being able to sit during a lecture by the Honorable Justice Sotomayor of the United States Supreme Court. Now, she was posed a similar question. And I have to say that I agree with her answer, that sometimes the law does produce unfair results, that you have to apply the law, and you have to apply the law based on the evidence that's presented to you. And sometimes, unfortunately, the result is unfair. It's not what you want to do. But that is something that if somebody believes that the law is unfair, that's something that the legislature has to address, because all the courts can do is apply the law. And only if the court, and the judges are here to interpret the law. And only if we find that a law is unconstitutional, can the law not be applied.
Well, that's one reason why I asked that question. A client will come out of court extremely upset and says the system was not fair to him. the case was presented by him, by his attorney, and he got whacked, so to speak, street term. But I think sometimes a judge is forced to interpret the law the way the law is. He felt that there was not much common sense because the judge was just following the line of the law. I says, well, that's what the judge is there for. They have to follow the law. And he says, well, don't common sense comes into certain case. And I'm not an attorney, so I was just kind of lost for words, and I just kind of left it alone. But sometimes they come out of court saying the entire situation was not fair, and it
Well,
happens sometimes.
the judges, as a judge, it's our obligation to be fair to the individuals that appear before us, to treat them with respect, to give them the opportunity to be heard, to present their evidence if it's properly introduced as evidence into court.
So it's fair to say that citizens has a good access to justice.
Well,
That's a different question.
That's a different question. Having the opportunity to present, have access to the court is one thing. Are they going to have? Can they properly present the case? Because then there's a question: what's evidence or what's not? You may have a dispute or something to argue, but if you don't present it in a proper fashion, there's procedures. Like I mentioned before, the criminal law. The criminal law is governed by the penal code and the criminal procedure law. There's a certain procedure to bring cases. And again, the civil law, there's the civil procedure laws and rules. There's a certain procedure. So if you don't bring the evidence forth in a proper way, then the person may say, hey, I didn't get heard correctly or what have you. But there's a certain protocol to present cases.
So for instance, when somebody appears before me and they say, I want to appear pro se, meaning I want to represent myself, I tell the individual.
That's the client saying that they want to represent themselves without an attorney.
Right.
Okay, go ahead.
It's Latin based. Go ahead.
Okay.
I say to the individual, are you sure you want to do that? Because if you represent yourself, if you act per se, the court cannot assist you. You have to know what are the rules of evidence. You have to know when to object. You have to know when to how to introduce evidence. And that's something for the individual who's not trained in law. That's something very difficult, because if you're not trained in the law, you may think that you have great evidence, but you don't know the proper way
How to present it.
How to present it in court. So the judge is bound by the rules of evidence, and if you're not presenting it the proper way, then the judge cannot admit it into evidence and look at it and make a determination based on those documents or those photographs, whatever it may be. So sometimes you have individuals who say the judge was being unfair, the court process is unfair, and sometimes it may be, but most of the time what it is that the individual does not know how to properly present the evidence. And one of the things that I've always said to individuals who are appearing before me is think long and hard before you say you want to represent yourself, because the court cannot give you legal advice. The clerks cannot give you legal advice. And then, so when you say, do you have access to justice? Sometimes the answer is you may not, because you have a situation where some individuals cannot afford to hire an attorney, so they do not know what their rights are. So that's a very big concern, and you know, for some instances there are agencies that are able to assist. Some things the court can give for attorneys that are paid by the state. So for instance, if you're charged with a crime, there is, in New York, you are entitled, if you cannot afford an attorney, to have one appointed for you. But it doesn't mean that just because you want an attorney, you're entitled to one. So if you have the means to pay for an attorney, the court cannot, and you don't want to pay for an attorney, the court cannot just assign one to you. Same thing in certain family court issues. So for instance, custody, the court, or custody, child neglect, anything where your child could be taken away, the state can assign an attorney to you. But there are other issues that affect an individual's daily life. For instance, a divorce, how assets are divided, that the court cannot provide an attorney to you free of charge. So if the person cannot afford an attorney, sometimes that may be difficult because they may be placed in a very difficult situation. And when you say, is the court fair? The court's doing their job. They're introducing, they're requiring them to comply with the rules, and sometimes that may lead to an unfair result.
I happen to agree with you partially. I think if someone goes to court, it's best to have legal representation, a capable, competent attorney. I don't care how smart you are. You don't know law. You don't know regulation. You can give a judge a hard time, but after a while, the judge would get tired of your nonsense. You're not prepared. You don't know the law. You don't bring in your case properly prepared. And a judge is not a babysitter. They are there to do business and to get things done properly. So I think each and every one should find a means in certain cases like that is to get an attorney. One of the reasons why I brought up that question, and this falls in, probably Mr. Diaz might have to answer it. A lot of things happen to immigrants in this nation. Sometimes they are picked up, and because of the new rules of the Trump law that he put in at the time, they just get deported. They don't get the access to justice, or sometimes they don't get access to go to court. So that's the reason why I asked that question. This is a total different case, obviously, what I'm presenting here, but things like that happen. And I love the answers that both of you all gave. And I know that, there are certain things you can't answer, but my concern was mostly because of the immigrants, things that happened to them.
Well, let me say this. Again, I want to premise by the fact is we cannot give an opinion. I will say a lot of people say that the immigration system or the laws are broken. Okay? I'm not saying that I won't sound like some other elected official but one thing is in immigration court, you're not entitled to an attorney. Just like Judge Elmore indicated that in civil matters, you're not entitled to a free attorney. You're entitled to an attorney in criminal court, for instance, because our Constitution values the deprivation of freedom in someone's life so high that they go out of its way to provide at least legal counsel. Okay, doesn't say it's going to be the person with the best experience, but at least they'll provide a legal counsel if one cannot be, if you cannot afford it.
Assigned to them.
And in certain other cases, like she mentioned, where custody or juvenile delinquency. I think I'm disappearing again, but oh, there I go. But in immigration law is the same thing. You're not entitled to an attorney. And I had a case where a woman and her husband were arrested for drug conspiracy, possession of drugs with intent to sell, and this by the federal government, a federal case. And in the case, she cooperated with the prosecutor and testified against her husband because she had children. She was thinking, what's in the best interest of the child?
Sure.
Now, her husband, who the evidence was the person involved in the case heavily, she was just apparently didn't even know what he was involved in, and then got caught up in the whole thing. She testified against her husband. He was eventually prosecuted, did about 11 years, and was deported. Now she's being deported now because of the drug sale commission. She's considered to be aggravated felony. And I was trying to fight. Listen, if you send her back, and he's made threats, her husband saying, once you come here to Dominican Republic, I'm going to kill you. So I was trying to get that to be considered. And the judge denied after years because saying, I don't have, under my limited scope of the law, I cannot cancel her deportation. So the case is an appeal and it's pending, but that's a case that some people might not consider a just outcome. She cooperated with the federal authorities. The evidence was presented to court. It was not an issue. They believe she has a credible fear of imminent death or torture. But this person, because he's not part of the government, it's not solid per se, all sorts of other questions. Will some people consider that a just result? And the judge was saying, I find it credible, but under my limited authority, I cannot cancel this deportation. So it's tough sometimes.
Very tough and complicated. As we get back on International Grapevine, we're going to continue talking to my two special guests about the justice system and access to the justice system. We'll be right back on International Grapevine.
I think most Americans believe that after you commit a crime and pay your debt to society, the punishment ends. You have the chance to rebuild your life and get a fresh start. But the reality is much harsher. We punish people with criminal records long after they've paid their debt to society, and we all suffer for it. Even simply being accused of a crime is just the beginning of perpetual punishment. A cycle of legalized discrimination, poverty, and reincarceration, a cycle kept in motion by 47,000 laws and regulations nationwide that restrict critical rights and opportunities. After contact with the criminal justice system, millions of Americans are denied employment and housing, denied college educations, excluded from public benefits, separated from their children, deported despite being legal residents, and deprived of the right to vote. These restrictions trap the poor and people of color in invisible cages that extend far beyond prison walls and criminal courts. Cages that lead to a lifetime of obstacles that undermine even the most earnest efforts at rehabilitation and redemption. Cages that send the message, you will never be a part of society again. This is not some isolated problem. 95% of all incarcerated people will return home at some point. Each year, more than 600,000 people are released from jails and prisons. That's roughly the population of Boston or Seattle. Millions more are completing non-jail sentences like probation, community service, or fines. As reentry specialist at Brooklyn Defender Services, a public defense firm representing 45,000 clients per year, I work on the front lines to help people with criminal histories overcome their past and navigate the obstacles of their present so they can build a sustainable future. I try to help folks take responsibility for their own lives, but it's hard to do when the outlook is so bleak. Even for low-level offenses and misdemeanors, the aftermath of one individual's experience with the criminal justice system ripples out to entire families and neighborhoods and gets passed down from generation to generation. The result, more poverty, more crime, more incarceration. I see Javon, an 18-year-old young man who cannot live with or even visit his family, and cannot find an affordable apartment because he was convicted of gun possession and banned from all public housing. I see the dangerous shelters and street corners where he'll sleep. I worry about what he's going to have to do to survive, how long it'll be before he's back behind bars. I see how society loses when Judy, a 58-year-old grandmother charged with a misdemeanor, is fired after her arrest and barred from her lifelong profession as a home health aide. Unable to work, she's faced with eviction and can't support her family. When Malik, a 26-year-old father, is denied the opportunity to further his education because of the mistakes of his past, I think about how he and so many others are set up to fail. How a conviction on a rap sheet is only a snapshot of a moment in time, when all of us are dynamic, changing over time. The criminal justice system disenfranchises these men and women, preventing them from growing, from truly being free. I am among the very few fortunate enough to be living a second chance. 3 decades ago, I was involved in a crime that took the life of another human being. I spent over 24 years in prison for my role in that reprehensible crime. While incarcerated, I had the chance to participate in a pilot program offered to only 15 inmates that allowed me to pursue a formal education. Upon release, I found an employer willing to look beyond my criminal record, one that saw the hard lessons I learned in prison as an asset, not a liability. Affording people a real opportunity to re-enter society isn't just good for individuals and families. It's good for all of us. Meaningful re-entry increases productivity, reduces poverty, and saves money. Most importantly, it makes us safer by eliminating the circumstances that perpetuate cycles of crime and punishment. People already get punished harshly by the system, but they shouldn't receive a second sentence that makes discriminating against them legal for the rest of their lives. By restoring full rights of citizenship to people after they've been through the system, we can start to end this cycle of perpetual punishment. We can start to abolish the justice trap.
And we're back here in International Grapevine talking about a little bit about the court system and access to justice. And, you know, we're pleased and lucky to have 2 special guests who have 50 plus years combined in the system, and they have been kind enough to come by here to be our guests, to exchange some thought process for you, our public, to understand certain facts of the justice system. One of the things, and one of the questions that I want to get into a little bit more about the civil right system, but I have one question that a female requested that I ask. How effective can how important is a good lawyer in every cases?
Well, do you want to start with that, or?
Up to you.
Well, why don't we say this? This is a common sense thing. Again, I cannot give opinions, but the more experience and education someone has, it tends to be someone better. So I constantly believe that a person evolves over time. We're not the same person we were 5 years ago, 10 years ago, 20 years ago. So I've been practicing for 30 years. I graduated in '89. I feel old every time I say that, but so I could say, in my opinion, about myself, I'm certainly a better attorney than I was in 1989, and 2000, 2010, now 2020. I'm the best I have been in all that time. So now everybody's different. You could have a really sharp attorney who's been practicing for 5 years, sharper than someone who's been practicing for 20 years. So it's not something as easy said and done. So, but obviously, and again, we can't give opinions, but something that the judge.
No, I know you can't give. I know you can't give opinion, but I guess the proper way should be: what should a client look for to choose an attorney? It's more of a proper question.
One of the things that you want to look at, that I would think a client would want to look at in an attorney, is do they have a record of misconduct? If they do, they may want to ask their attorney, I see you have a record of misconduct. Can you tell me about it? And the person has to be satisfied with that attorney. The issue is, as a client needs to be able to have their questions answered by their attorney. There are good attorneys and there are not so good attorneys. I see that every day. There are some attorneys that I wonder how they became attorneys, because they have no clue how to introduce evidence, how to ask the question. And there is some truth to what Mr. Diaz said, that as we age, we become better attorneys. We learn
Or experience.
But unfortunately, there are individuals that have a law degree, but they don't get better with time. There are young attorneys that are very sharp. They know they know what they're doing. They have the advantage of youth. They have the advantage that the law is fresh in their minds, because they recently graduated, and they just need help in applying the law, because they learn theory. So they need assistance in in the practicalities of the law.
Let me just follow. I don't want to cut you off, but I want to follow up on that. It's also important to get an attorney that specializes in your area. Just like a doctor, you're not going to hire a neurologist to do surgery on your foot.
No.
If you're in a matrimonial matter, you're not going to get a criminal attorney that's one of the best in criminal defense. Okay? So then, obviously, he's not going to do a good job. I have people coming in to see me, and they want to have a problem. They say, "Oh, Lester, we heard a lot of good things about you. I want you to help me with a certain case." And it's something I don't. Let's say is workers' compensation. It says, "I'm not that specialized, and I don't have a license to steal from you. I don't feel comfortable taking your money and representing something that I'm not specialized in.
Exactly.
That I don't have the experience." And that's because I'm conscious. So I'd rather do right by the clients that are trying to make money. Just take anybody that comes in. So it's very important. But just like Judge Alamar indicated, you want to look at has this person has a record of misconduct. You have access to that. People now these days you can see a lot of things on the internet. Is a person specialized, experienced in my particular problem? So these are things that you inquire and look for when you're looking to hire an attorney.
It's like anything else, and I think most judges see that more than anyone else. An attorney has to be really prepared and well organized for a case. And he should know the case going in. I'm quite sure a lot of judges see incompetence in attorney, and they also see attorneys that are sharp like a brain. They pick up on things and they're great. I think the key component, and again, I'm not an attorney, but as a bank, I had 3 or 4 attorneys reporting to me as a senior vice president. And I always felt before we went to court, because some of them reported to me, I wanted to know how prepared they were for the case. Because if they're not prepared for the case and doesn't have the knowledge, it clunks. And it's a difficult thing. And being an attorney is not an easy thing. I mean, you're under a lot of stress. You see a lot of things that goes on.
So let me just, you hit a good point. Because again, those are a lot of factors. Is the attorney that does he have a record of misconduct? Is he specialized? Does he have experience? Is he prepared on this case? Did he review the evidence? And did he get all the evidence in as well? So there's a lot of factors, because you could be the smartest guy, but if you don't know the case, then you're not going to do as good of a job. So it's all, and look at what's the qualifications to be an attorney. Again, I've been practicing for 30 years. So at minimum here in New York, you have to be at least an attorney for 10 years. I understand. An attorney for 10 years to be a judge. That's my understanding. Right. So
yes, it is.
And Judge Elomar and I have much more than that. So and then now she's been practicing as a civil court judge, or she's been practicing as a judge, period, because she's been in 2 different courthouses.
Right.
And so she has more experience than certainly me going in. So there's a lot of factors to go in and to the thing. So when you're looking for an attorney, these are things to look at. Again, I reiterate, just because I want the audience to get it. See, does he have a record of misconduct? Has he had complaints of stealing money from misappropriating funds from his client? Look at the recommendations from other clients. Okay, there's some websites, because now these days you put reviews on certain people. What are the other clients?
Well, in all fairness, sometimes those, sometimes even great attorneys, unfortunately, are going to have a disgruntled client. So
that's another factor.
You can't. Those reviews may not necessarily be 100% accurate.
And sometimes they are overworked with a lot of cases too. They're human.
That's
Things
true.
like that happen sometimes.
There are times where there's a certain result and the client doesn't like the result, and it's not the fault of the attorney, and the client writes a bad review. The attorney's only so good sometimes as the information that they're given to by the client. So if you have an attorney, a client that comes in and tells you ABC, and then when you're in court and they're under cross-examination, they say XYZ, and you see that they were basically not being forthcoming with you, and they get a different result. Well, maybe if they had told the attorney the XYZ from the get-go, the attorney could have done things differently.
I agree with you. I agree with you 100%.
I've had cases like that they hide things thinking that it'll get through, and it comes out. It doesn't help to lie to your attorney. But just following on something that she said when she was talking about Judge Elomar on reviews, a lot, for whatever reason, they didn't get the outcome that they wanted, and they're looking for someone to blame. They'll blame the court, the system isn't fair, or my attorney's no good, but they're looking for a scapegoat, someone to blame, when a lot of times rather than blame themselves.
I agree with that. All right, let's get back again in civil case. What are the first 3 major steps in a civil case?
Well, the first step is you have to file a lawsuit.
Okay.
And you file a lawsuit when you purchase the index number in New York State.
All right.
Once the index number is purchased, then it has to be served. So somebody over the age of 18 who is not a party of the action has to serve the summons on the complaint or the summons with notice upon the defendant. Then the defendant has a period of time to answer. So once the complaint is answered, then the discovery phase, where the parties exchange the documentation. There may be not only documented exchange, there may be what's called depositions. And once all the discovery is done, then the attorneys can make an application so that the case goes to the trial calendar and a trial takes place.
So there's a lot of steps from beginning to end. Okay, just in civil court and Supreme Court, you have to pay like Judge Morris said, for the index number. That's the number of your case. That's the first step. Then serving papers, because under our system of law, you want the other side that you're suing to have an opportunity to be heard. So before the court gets involved, they want proof that you handed the complaint, the petition, whatever it is, to the other side. Obviously, you can't do it. It has to be someone, like she said, the 18 or over, not a party to the action. So if I'm suing Joe Schmo, I could hire, get Julio in America to serve the papers, because I think he's over the age of 18, if I'm not mistaken, and he's not a party to the action. And then they write what's called an affidavit, notarized. I served the papers so-and-so. This is their physical description. This is a date, time. So once you get those documentation, you bring to the court says, okay, now I see by your affidavit that you personally serve the papers on this individual. Now I have jurisdiction to act in the case, and then it takes from there.
Everything is done properly.
Go ahead.
Everything is done properly before it gets to the judge.
And then one thing that most individuals most defendants don't realize is that a lot of people have said to me, Judge, I want you to vacate a default judgment, which is when a person fails to answer a complaint because I was never served. There are times where you discover that their claim of non-service is based on, well, I never signed anything. And
They avoid to serve. They avoid to serve. They hide.
Well, no. What a lot of individuals think that for them to be served, they must sign a paper acknowledging that they received the document, and that is not the case. The law states that you have to, if a person gives you the papers, if you decide to cross your arms and not take the papers, and they leave the papers on the floor, you were still served.
So, for example, I want to serve papers on Karina. Here's the papers, and she lets it drop. She doesn't even. That's proper.
Yes.
She didn't sign papers, but the person who served the paper says, "I gave it to this person on such and such."
In their hands.
Yes.
No, you don't have to have it in their hands. If I say to Nestor, I'm serving you with papers, and Nestor doesn't give me his hand, doesn't take it, and I just do this and I drop it.
I say no service, no service. That's good.
He was served.
Wow.
I let it up on the floor. I wasn't served. There you go. And it says it's proper service. And you judge Walter Lee said he didn't accept the papers, but that's on him. That was proper service.
Walk us through, for the education of our audience, a deposition. When a deposition is necessary and how it's handled. And more importantly, after the deposition and the client goes to court and is questioned by the other attorney, what happened?
Let me just start by this. A deposition is a form of discovery, because in the course of a case and before trial, go to discovery to get evidence. Each side has an opportunity to get evidence.
Right.
There's different forms of getting discovery. Deposition be one of them.
So basically, a deposition is when the individual goes and testifies under oath. It's usually the attorneys, their respective clients, and a court reporter. So the attorney for the other side can ask the individual questions under oath. Those questions their answers to those questions can then be used during the course of their testimony. So, for instance, a witness says ABC under oath at trial, but they said XYZ during their deposition. Their attorney, the attorney could recall their attention to their deposition and discredit them. They could impeach their testimony because their testimony is inconsistent. They said one thing one day, a different thing another day.
Mr. Lee, let me tell you something else about depositions and discovery. That's also an effective tool in resolving cases, because a lot of times attorneys see how strong or weak their case is, and it's more likely to resolve the case. Oh, we have a weak case, or we have a strong case. And because trials can often be very expensive and tedious, and you never know what the result is, no matter how good you are. Okay? A lot of times you just don't know.
And that is why a majority of the cases end up in settlements. Because sometimes what will happen is that I will say to individuals, okay, counsel, you have to remember that these are the strengths in your case and these are the weaknesses. And I'll say that to both parties. Now, in light of that, is this a case that you really want to take to trial, or is this a case that you want to talk to each other and try to resolve amongst yourselves? And a lot of the times, they will settle the case between themselves because they're taking a risk as to what I will do as a judge, and if it's a bench trial or if it's a jury trial, what the jury's going to do. I always told when I was a litigator, I did a lot of matrimonials and a lot of criminal defense cases. So when I had my criminal cases, I would say to my clients, you don't know what a jury is going to do. That's the equivalent of taking a dice and going to Atlantic City and playing. You don't know if you will win or if you will lose. You have been given this offer. With this offer, A, B, C. And sometimes I would say, I think it's a good offer for these reasons, and I think that it's a bad offer for X, Y, Z.
I hear, but in many example in criminal cases, it has been documented by the New York Times that most minorities tend to settle a case because they're not having the proper legal advice of a good attorney. And in some cases, they feel that it's better to take a deal than be subject to go to trial.
Well, that may be the case. I can't really answer that question. All I can say is that during the time that I was an attorney, I sat down with my clients. I explained to them, the pros and cons of taking their plea. I had one situation where I remember clearly one of my clients was charged with a particular crime. I felt that, and I said to my client, I go, you're being given an offer of 2 years in jail. And I said, if you're found guilty, you face a time period of 2 to 7 years. So the minimum 2, maximum 7. You could also get probation if you go to trial and lose. So it could go from probation to 2 to 7. And I said, they're offering you the minimum of 2 years. It's your decision what to do.
So he has the final say what he wants to do.
Of course. And I said to him, and I go, in my opinion, my personal opinion, I said, I don't feel that they're offering you a great deal because they're just giving you the minimum of 2 years. They're not really working with us. And I said to my client, I go, but the choice is ultimately yours. My client made a decision that he decided to roll the dice and go to trial. And we did well. He got an acquittal and he was very happy. But you also have to you also have to explain, what? You can
go either or.
Go either or.
See, it's like the saying, a bird in the hand is worth 2 in the bush. When you make a settlement, an agreement, you know what you're going to get. When you go to a trial, especially a jury trial, you're playing lotto. And I ask my clients, this is your life. Do you want to gamble? Or I can't make the decision for you. I could explain to you my experience. This is the way I see things could possibly be. But no one could say to a conclusion, very few times in my experience, could say this is exactly going to be the result. Because when it's somebody else's hands, especially 12 people, how can you decide? You can say
you don't know how they're going to react.
But the only person that make a decision is your client. This is what it is. You can ask for my opinion, but ultimately the decision is yours.
And when I was at one point I presided in criminal court, and there were times that the people will make a certain offer, and sometimes I would tell the defendant who was appearing in front of me, you need to go, before rejecting this, you need to go and speak to your attorney, the pros and the cons. The offer right now is X. Sometimes it involved a non-criminal disposition. And I would say, I don't know what the evidence is what the evidence is, what the prosecutor is going to show. It may be that if you go to trial, that the jury may find that the people have met their burden of proof and that and they find you guilty beyond a reasonable doubt. So you need to sit down and really speak to your attorney about the pros and the cons of this offer before you reject it. And sometimes I would say, knowing this, do you want to have this case called a second time, or would you like an adjournment to speak to your attorney before you outright reject this deal?
Interesting, interesting. Quick question. How many courts are there in the district and what is their responsibilities?
How many courts there are?
Yeah.
Well, I said there's the criminal court, there's a civil court, Supreme Court, and I mentioned briefly that in civil matters are basically because there's other courts that are more specialized, but it's the civil here in New York City, civil court and Supreme Court. Civil court handles all matters up to a maximum of $25,000.
Okay.
So when it's $25,000, then you go to Supreme Court.
And in Supreme Court, you also deal with, so basically the court structure is you have small claims. Those are cases under 5,000. Then you have civil court, which is cases under 25,000. Then you have the Supreme Court, which is the court of general jurisdiction that can deal with cases above 25,000, as well as any case involving issues of equity or issues of divorce. Then you have certain specialty courts, like the family court, which deals with issues of custody, child support, child neglect, child abuse. You also have the Court of Claims, which is cases against the state of New York. You also then you have your appellate courts. So you have the appellate term, which deals with appeals from the lower courts, from the civil court, and from the lower criminal courts, which lower criminal cases deal with cases a misdemeanor or less, which are punishment 1 year or less.
That was my next question. When does the appeal court comes into the picture?
So the appeal court comes after after the trial court renders a decision. So if it's if it's the civil court or if it's the criminal court, the case would go to the appellate term. If it's from Supreme Court or if it's the Supreme Criminal term, the case also goes to the appellate division. If the appellate division, if you're not satisfied with the decision from the appellate division, then you can make an application. There are certain cases that are as of right go to the New York Court of Appeals, which is the state's highest court, or you can make a request if it's not a matter of right for the court to hear it. So usually, if there is a division in the different departments in New York has 4 departments. If all the departments have a different rulings on this particular issue, the Court of Appeals may say, we want to hear this case because we want to make a final determination for all of the departments. One of the cases that I argued before the Court of Appeals dealt with the issue of contempt. And did civil or contempt require a person to willfully act in a certain way? And the first department said willfulness was not an issue. Second department said willfulness was required. So there was a difference in the different departments. So finally, when the Court of Appeals decided they wanted to hear that issue, and the issue was heard, and the Court of Appeals made a final determination that for civil contempt, there is no need to show willfulness.
I was under the impression always that appellate court only comes in when the court system makes a mistake.
No.
Not at all?
Well, yes, it does.
Well, if the person has to appeal first.
Absolutely.
Right.
The litigant is arguing that the
Court system made a mistake.
Right. A person appealing says, "Oh, they made a mistake. I want to appeal it." So that's it. It's not a question of fact that they made a mistake. That's your argument. I think they made a mistake. That's why I want to appeal.
And the appellate division is not calling in witnesses to hear the case. What the appellate division is doing is they're looking at the record from the lower court. So that means they're looking at the person has to file a brief, and the court's going to look at the brief and the record on appeal, the transcripts, and make it. And after reading all of the record, they're going to and oral arguments, they're going to make a determination whether they're going to sustain the decision of the lower court or they're going to reverse.
So the things that they could look at was the evidence properly presented. Should they have consider certain evidence or not? These are all sorts of things. Let me just say something about the criminal law area. If a person is acquitted, or in other words, found not guilty, the district attorney cannot appeal that.
Correct.
Okay, so that even though they may think there was a mistake, the prosecutor can say, "Oh, let me try to appeal it so you can go to jail." No, that's it. Once a person is found not guilty, that's it. Now, if a person is found guilty, they could appeal that.
Okay.
Okay, so and they're going to be arguing there was a mistake made and things of that nature. Okay, now when the Judge Almore indicated there's 4 departments, it depends on what geographic area of New York State there are. There's 4 appellate departments depending on the geographic location. For example, the first department is Manhattan
And Bronx.
and the Bronx.
And the
And
Bronx
the second department is Queens
and Brooklyn.
Queens, Brooklyn, Nassau, I believe also Orange County.
And that's Staten Island?
I believe Staten Island.
We lose Staten Island as well. But it's in that department, there's so many cases concentrated that they have a whole department for that. Just like in the first department, it's Manhattan and the Bronx. There's so many cases. Then the third and fourth department get divided between upstate. Okay? So I just wanted to clarify that. She also indicates something in criminal court when the people of the state of New York are represented by the district attorney's office. So it's
Yes.
not like a lot of people come and make a decision. It's a district attorney is acting on behalf of the people. See, in a criminal case, they have the people of the state of New York versus Joe Schmo, whatever it is. That's the district attorney who represents the people of the state of New York.
Well, on that note, I want to take the opportunity to thank you both for being my special guests and bringing so much information to our viewing audience. For those who were not clearly about the justice system, how it works. We don't have words to thank both of you for being so kind and to be here discussing these things.
Well, we like to thank you very much for the invitation to come to the show. We like to have this opportunity to talk to your audience, your gracious audience, and we're very gracious for your time. Before we leave, I just want to leave you again with knowing that Judge Almore is a candidate for the Supreme Court.
Yes,
I hope that you vote for her. And
I certainly will.
We're not allowed, again, another thing, we're not allowed to endorse, but again, she's a candidate for.
Well, I'm going to say this. I'm a candidate for Supreme Court for Queens County. Mr. Diaz is a candidate for Civil Court of Queens County. And if you have the right to vote, you need to go out to vote for whoever you feel is the right individual.
I still have a base in Queens. So I'm a New Yorker.
Okay.
I still do. Still have a home there.
Glad to hear it. Okay. Just like what she was touching, the most important thing is to go out and vote. Period.
Yes, indeed. No
Make your
question
vote.
about it.
Your vote is your voice, your opportunity. Because if you don't vote, you have no right to.
You shouldn't complain.
Complain, exactly.
You should not complain. Again, on those strong words, I want to thank you both again. And I want to say to my family of the Grapevine who watch our show, thank you for watching the show. We hope that it was very pleasing to you and educational to a certain extent. This is Wallingford Lee saying good night for International Grapevine. And thank you for being there with us all the time.
Thank you for having us.
Thank you.